Good morning, this is your Kelso Report for Tuesday, October 4th, and I'm your host, Clark Kelso. In the Internet age, the question has frequently arisen whether and under what circumstances information held by a third-party service provider can be subject to judicial disclosure orders. For example, as consumers and users, we trust that emails, which may be stored on a third-party servers, will not be routinely disclosed to others absent appropriate legal process or our consent. One of the primary federal statutes that regulates the terms of such disclosures is the Electronic Communications Privacy Act, which was enacted way back in 1986 and has had several amendments since then as technology has advanced. In Suzlon Energy versus Microsoft Corporation, the Ninth Circuit had to interpret the act against the backdrop of a petition to compel production of documents under Title 28 U.S.C. Section 1782 to assist in judicial proceedings occurring in Australia. The petition sought production of emails by one Rajagopalan Sridhar, who was the defendant in a civil fraud proceeding in Australia. Sridhar is a citizen of India and is imprisoned abroad, but the relevant emails are stored on a domestic server owned and managed by a domestic corporation, Microsoft. Microsoft objected to the production on a number of grounds, but the Ninth Circuit granted relief from the request for production under the Electronic Communications Privacy Act, or the ECPA. The Ninth Circuit had previously held that the ECPA limits Section 1782 by making it illegal for an entity that provides an electronic communication service to the public to produce the contents of its stored communications. The issue before the court in yesterday's decision was whether the protections afforded by the ECPA extended to foreign citizens. Prior case law involved only United States citizens. The court did not have to go beyond the plain language of the statute, which defined a user as, quote, any person or entity who uses an electronic communication service and is duly authorized by the provider of such service to engage in such use. Given the use of the phrase any person, the court had no difficulty concluding that the scope of the ECPA encompassed emails held by a domestic service provider for a foreign citizen. The court also noted that as a practical matter, in our global world, it will be nearly impossible for a service provider to determine who was and who was not a United States citizen at the particular time an email was transmitted or now is being held. As a result, the Electronic Communications Privacy Act now protects all communications, whether from U.S. citizens or non-U.S. citizens, so long as the communications reside on servers located in the United States. The Ninth Circuit expressly reserved the question of whether the ECPA applies to documents stored or acts occurring outside of the United States. So that issue remains still to be decided. And now our one-liners, first in the area of class actions. In Washington versus Chimei Inc. Corporation, the Ninth Circuit held that parens patriae suits brought by the Attorneys General of Washington and California in their respective state courts should not have been removed to federal court under the Federal Class Action Fairness Act, since the parens patriae status of the suit does not transform it into a class action under the Act. The actions allege that the defendants engaged in a conspiracy to fix the prices of thin-film transistor liquid crystal display panels, and that state agencies and consumers were injured by paying inflated prices for products containing those panels. Defendants removed both actions to federal court, asserting that the damage claims in the actions were just thinly disguised class actions. The Ninth Circuit agreed with the district court that the actions did not constitute class actions under the federal statute because Congress intended the statute to apply only to those state actions that traditionally have been styled as class actions brought by a representative party. In other words, actions similar to a class action under Rule 23 of the Federal Rules of Civil Procedure. The parens patriae actions brought by the two states do not fit that definition, so the cases were remanded to state court. Next, in the area of criminal law, in United States v. King, the Ninth Circuit affirmed the defendant's conviction for injecting fluids into deep wells without a permit in violation of the Safe Drinking Water Act. The defendant asserted that the government needed to prove that the injected water had an adverse impact on an underground source of drinking water. The Ninth Circuit rejected this argument because it was clear under the statute that the burden was on the defendant to secure a permit before injecting water into a deep well, and part of the burden of getting that permit was that the defendant had to prove the injection would not allow the movement of fluid containing a contaminant. So the act was violated when the defendant injected fluids into deep wells without a permit. Nothing more was required. The court also upheld the statute against a Commerce Clause attack on the rather obvious ground that drinking water is an economic commodity, and that, as discussed in the legislative history of the act, unregulated injections exert a substantial economic effect on drinking water. The conviction was affirmed. Next, the criminal sentencing case in United States v. Gilchrist. The defendant who entered a guilty plea to 18 counts of embezzlement and bank fraud related to two schemes to defraud Wells Fargo: an embezzlement scheme and a check-kiting scheme. He was sentenced to 25 months imprisonment plus 5 years of supervised release, the high end of the sentencing guidelines range. As part of the sentencing calculation, the court subjected the defendant to a 2-level enhancement for obstruction of justice because the defendant had filed a fraudulent lawsuit against Wells Fargo to divert attention away from himself and had repeatedly lied in that lawsuit. Rather incredibly, the defendant argued that because he was unaware that he was already the target of a criminal investigation when he committed the perjury in the civil action, the district court should not have given him a 2-level enhancement for obstruction of justice. This argument has been rejected by several other circuit courts, and the Ninth Circuit joined its sister courts in holding that no awareness of the criminal investigation is required. It is enough that an investigation is ongoing at the time the defendant makes false statements that obstruct the investigation. Next, we have a right to jury case in Imperial County Behavioral Health Services versus Joseph W., where the 4th District held that the defendant in a conservatorship proceeding waived his right to a jury trial. When the defendant requested a hearing on the conservatorship petition, the trial court interpreted the request as one for a court hearing. Although the 4th District held that the trial court had misinterpreted the request for a hearing as a demand for a court trial, the appellate court nevertheless rejected the defendant's argument because the defendant failed to object below to the court trial and instead appeared at and fully participated in the court trial. Having failed to object below, the point was waived and forfeited. Next, in the area of government law, in Brown v. California Correctional Peace Officers Association, the last large case challenging Governor Schwarzenegger's furlough program came to an end. As expected, the 1st District held that the California Supreme Court's decision in Professional Engineers v. Schwarzenegger, where our High Court upheld the furlough program, resolved CCPOA's challenges in favor of the state and against CCPOA. The Supreme Court in Professional Engineers essentially held that the legislature had inadvertently ratified the furlough program, and given that legislative approval, CCPOA's claims were meritless. Finally, in the area of administrative law, in DeSico v. California Coastal Commission, the 2nd District held that the California Coastal Commission had appellate jurisdiction over a county's approval of a development project when the project required approval of a subdivision. If the project had been only a principal permitted use development without a subdivision component, then the approval would not have been appealable. The issue arose when the plaintiffs applied to the county for a permit to allow them to subdivide their 4 contiguous parcels into 5 parcels, so they could construct 4 townhouses and a motel. The county sent the commission a notice of its decision and asserted it was not appealable, which the commission disputed. Simply applying the plain meaning of the Commission statutes dealing with appellate jurisdiction, the court held that a subdivision was expressly defined as a development and that it was clearly an appealable decision. Because of the Commission's decision, a local citizens group filed an appeal of the county's decision, so that appeal will now go forward. I'm sure the landowners are now thinking to themselves, why didn't we just go with 3 townhouses and a hotel? Well, that's it for today's Kelso Report. Have a great day in the law.